Welcome back. Today we're talking about what I believe might be the most misunderstood portion of criminal law and criminal procedure, and that is the Fifth Amendment to the U.S. Constitution and the Illinois Constitution. It's actually a much more complicated bit of law, and how it's actually applied is a lot different than how many people believe it is, based on movies and television shows, and I think just a general misunderstanding about what the Fifth Amendment is, how it applies to a certain situation, when it applies to a certain situation, and then more broadly, the term Miranda or Miranda rights that ties into the Fifth Amendment. I'm going to start with actually reading the Fifth Amendment because there's a great deal of language in the statute or in the amendment itself that I would imagine a great deal of people have no idea is there. It's not that long, but there's a great deal more language there than I think you might be aware of. So I'll start just with that. The Fifth Amendment, this is to the U.S. Constitution, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of an indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in the time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Okay. It's kind of a lot there. It wasn't that long to read, but there's an awful lot of subclauses or subportions of one amendment that really applies to both criminal law specifically, but there's a smidgen of a cutout as it relates to certain types of civil cases that's right at the end. Now, generally speaking, most people think of the Fifth Amendment as not having to testify against yourself or giving testimony against yourself or having to give testimony against yourself or implicate yourself or incriminate yourself. And that's true. That's certainly a part of the Fifth Amendment, and it's probably the more well applied or well understood portion of the Fifth Amendment, but it's obviously not the only portion of this. What this video is going to focus on specifically is the Fifth Amendment portion of Miranda, though I want to touch on some of these other subjects under the Fifth Amendment as well. So first and foremost, there's a description here of not having to answer for a capital or otherwise infamous crime. In Illinois, that's understood to be a felony offense, that there's usually an indictment or a finding of probable cause from a grand jury, though it also can go before a judge for what's called a preliminary examination. It's the same or different side of the same coin, where there needs to be a showing from the state or the prosecutor's office that they have probable cause or enough that a reasonable person would believe that the defendant has committed the offense. And that can be done either at a grand jury, which is behind closed doors. The defendant isn't there. His or her counsel is not there, but you'll get a transcript of it afterwards. Or a preliminary exam, which would be before a judge. It's live and in court. In fact, many of them are still done on Zoom, at least in Cook County. But the defendant is there. His or her attorney is there and can ask questions. But because the threshold is so low, we're just talking about the finding of probable cause, that if I've participated in 1,000 preliminary exams, 999 of them, they, being the state, have achieved that low level of finding probable cause. So that's not really where a case is won and lost, but it is just a small hurdle that the state has to go through in order for a felony case to continue. The next portion we're going to skip over, which again, that's really going to be the main focus of this video. So we're going to get to that in just a little bit. And that's about testifying against yourself or giving a statement or speaking to the state or to the police. The third portion of this is discussing being deprived of life, liberty, or property without due process, meaning there has to be a process, an actual order of events where you have an opportunity to have an attorney to work through the evidentiary process. And depending if you're criminal law or civil law, where you're at in that process, there's different levels of evidentiary proof. We just talked about one of them. That's probable cause at the very beginning of a case. It can go higher. Certainly at a criminal trial, it's the highest evidentiary burden. That's beyond a reasonable doubt. That's at a trial. So it goes from very low to very high at the beginning or at the end of the case, depending on what part of the process you're in. But that's talking about there being a process, there being steps and safeguards to make sure that before your life is taken by either literally being put in jail for the rest of your life or being taken from your family, that there's a process in place that's tying to liberty as well. That again, it's your ability to possess a gun, your ability to go to work, your ability to live in certain places can be infringed upon by having a criminal case or having a criminal conviction. And then property, of course, we're talking about money or your assets or a home or whatever that may be, that if you're going to be forced to give that up, there should be procedural safeguards. There should be a process in place to protect your life, your liberty, or your property. The very last subsection of this that I'll just touch on, that's not the real basis of this video, is shall not nor shall private property be taken for public use without just compensation. That's a term maybe you've heard of before. It's eminent domain. The classic example of that would be the government or the state or maybe the federal government is expanding a highway or a road, or they want to build a road somewhere. And in order to achieve that goal, this public use, they're going to need to take property. Some of which may be or privately held. Maybe it's your home or a part of your yard, as an example. Well, the government certainly can take that property, but they have to show that this is for a public use, and there can be a process to that as well. But if they're going to take your property, they also have to provide just compensation. Usually that's going to be money. There aren't really a great deal of other examples of what type of compensation you can get beyond monetary compensation, but that's the classic example. Well, that brings us back to the real point of this video, which is not having to testify or give testimony against yourself, be a witness against yourself. Miranda rights. This goes hand in hand because that's what we're really talking about. When are you required to answer questions of the police or the state? Very limitedly is the short answer. Usually when you're pulled over or stopped by the police, either in a vehicle or if you're walking down the street and you're having this contact with a police officer, there's really only limited information you have to provide. Usually it's biographical information. You may be required to identify yourself, give your name, and that's obviously found on a driver's license or maybe on a state ID or something like that. But beyond that, there really isn't anything else that you're required to say. It's a general misunderstanding. If you're in a vehicle specifically, an officer certainly can ask you out of the vehicle. That's usually going to be under the understanding that it's for officer safety, that they'd rather have that person out, perhaps by either the rear or the front of their vehicle where they can see that person. They're away from anything that may actually be in the vehicle, specifically weapons. It could be a knife or a gun or something like that. Also keeping that person away from perhaps hiding or destroying evidence. Contraband would be drugs, typically. So they may ask you to get out of the car. They're allowed to ask you for your biological information, your ID, and they certainly can ask other questions, but what are you really required to answer? Really nothing else. Because after that, you're now providing testimonial information, perhaps against yourself, or something that can be used against you. But the real, I think, point to make it right now is if you're stopped, either on the sidewalk or you're stopped and you're in a vehicle, you're certainly not under arrest yet. you've been stopped for speeding, or you ran a red light, or one of your headlights were out, or any multitude of other reasons why your vehicle may have been stopped or why you may have been stopped by the police on the sidewalk. You've provided your biological information, and certainly other questions are being asked. My advice is certainly be polite, be professional, but you can also decline to answer those questions because you're not required to do so. And that's maybe easier said than done. It's certainly an uncomfortable position, even if the officer is being polite and professional with you and being pleasant. No stop is ever fun. It's nerve-wracking. It's anxiety-inducing. It's scary, probably even upsetting, and it makes you angry under certain circumstances too. But the advice is answer what you must, which is pretty limited, and then be polite and professional otherwise, and decline to answer any other questions. You could certainly ask, am I being detained? Am I being arrested? Because that matters when we're talking about Miranda. Just being stopped by a police officer, even for a simple civil infraction or a traffic ticket, something like that, you're not under arrest. Miranda is not applying at that point, because Miranda can best be understood in two words: custodial interrogation. Two words: custodial interrogation. Now, what does that mean? Custodial. It means you're under arrest. You're not free to go, either because you've literally been told you're under arrest, or from the understanding of the circumstances you're in. Obviously, if your hands are handcuffed behind your back, not likely free to go. If you ask an officer and say, am I free to go? And they tell you no, naturally, you're not free to go. You're not allowed to leave. You're under arrest. And when you're under arrest and the police then want to ask you questions, just another way of phrasing an interrogation, they want to ask you questions and you're in custody, you can decline to answer those questions. And that's also at the point when the officer should be reading you those Miranda rights: the right to remain silent, the right to have an attorney, that one can be provided to you even if you can't afford one, that those are the basics of the Miranda warnings. And I think the most important portion of that, beyond the fact that they're telling you that you don't have to answer their questions and that you're entitled to have an attorney, is that anything you say can and will be used against you. Again, listen to that. The officer is telling you anything you say, anything that you say can, underline that, can and will be used against you. Again, think about that. They're outright telling you that anything you say can be used and certainly will be used against you, not to help you. And if you think about it that way, I don't believe anybody would answer questions. If you stopped for a moment and thought about exactly what they're telling you, that anything you're about to say is going to be used against you in a negative way, probably wouldn't answer those questions if you viewed it in such a negative way. And that's really what I'm imploring people at this point, is that there's no benefit to answering those questions. Even if you're 100% not guilty, even if you're 100% the wrong person, anything you say can and will be used against you. There's no upside. Answering those questions can commit you to things, make you appear to be a liar. And what I mean by that is you can tell a story that in no way, shape, or form are you adding details, or you're trying to make yourself look better, or leave details out, omission. You're not trying to do that. To the best of your ability, you're telling a story from beginning to end, everything you know, the good, the bad, the ugly. Well, later on, and sometimes maybe it's months, maybe even years later on, you're eventually facing these charges or fighting these charges in a trial, and it comes out that you left something out or you were wrong about a detail. Not deliberately, you weren't trying to lie, you weren't trying to pull a fast one on anyone. It's still going to be used against you. Other portions about what you share, again, can be 100% truthful. You're an honest person. You're just trying to share your piece of the story and what you know and what you saw and what you heard. You've committed yourself again to a story. You've committed yourself to facts that you were under no duty to do. That these were things that the state, the prosecutors, or the police would have to otherwise go around and prove by other bits of evidence, either from other witnesses or circumstantial evidence. They would have to prove this, but instead, you gave it to them. You confirmed that you were on the scene. You admitted that you fired the gun. You admitted some sort of ownership either over a vehicle or something that was in the car or a bag, or you provided some bit of information about knowledge about what was or was not in the car. You set a chronology of events of where you were and when. And in the moment, sometimes you don't even know why that would matter. You're like, I didn't say anything bad. I didn't admit to committing a crime. I didn't do anything wrong. And maybe all of that is true in the moment, but later on, what you just said, what you provided against yourself, is going to be used in a negative way against you. Because at the end of the day, the prosecutor's job is to get a conviction, and that's what they're going to do. They're going to use your own words against you, spin them as negatively as possible, and as little that you can give to the state, the better. And that really should be as simple as biographical information. What's your name? What's your date of birth? Your address? And really not much else. Provide your insurance if you're in a car. Again, that's about it. Anything else, you ask, am I under arrest? And if you're not, you can obviously leave. If you're not under arrest, if you're not being detained, you can end that communication with the police. Again, I would suggest to do so politely, professionally, be pleasant, but you can end that interaction. If you're not free to leave, if you're being detained, or if you're being outright arrested, well, then at that point, invoke your Fifth Amendment rights. Call your family or call directly to your attorney if you have one, and do not answer any questions. There is no upside. There's no benefit. You're not going to talk yourself out of a situation at that point, but you certainly can make the situation worse. Again, if you remember the language of what the police are even telling you at the time you're being interrogated, when you're given those warnings that you can remain silent, that you have a right to an attorney, and that anything you say can and will be used against you, and you remember that and you heed those words, you listen to those words, they're telling you they're going to use this against you, you would not answer the questions. So keep in mind, even though Miranda applies only to when you're in a custodial interrogation, remember those two words, your statement still can be used against you before you're under arrest, before you're in custody, before you're detained. And those examples would be, classic story would be you're pulled over, an officer asks you, do you know why I pulled you over? And maybe you do know. Maybe you know you're going way, way over the speed limit and that your tags are expired and that you have drugs in the car and any other number of things that maybe you know are going on or a basis for why they may be pulling you over. Don't answer that question. You're not under a duty there to tell them why they pulled you over, even if it's obvious. Let them provide that information. It's up to them to prove that they had a reason to pull your car over and give you a ticket, and then subsequently if they're going to search your car and so on. Don't give them information. It's the same idea during a search, that all you had to provide was your name and insurance and basic information. If you start talking about, whose bag is whose and what's in the back seat and what might be in the trunk and what you know and what you don't know, that's going to be used against you. It is not going to help. There's no benefit. I've talked about this in other videos, that again, even if you know that the stop of your vehicle, your person was bad, or you know that there was no basis to search your car, you're not winning that argument on the side of the road. Where you can win that argument is before a judge at a later date. So be professional, be polite, be pleasant, but don't provide any more information than you need to, because officers are just human beings. They're just people. They're potential witnesses. They can talk about what they saw and what they heard when they're on the scene. So if you make some sort of admission or just exclaim something or just say something, Miranda doesn't apply because you weren't under arrest and you weren't being interrogated. You just made a statement or answered a simple question that you could have decided not to answer. And an officer can come in at a hearing or at a trial and say, oh, yeah, I heard the defendant say that. He admitted it was his car, or he admitted it was his bag, or he said he knew there were drugs or a gun or some other contraband in the car. Anything you say can and will be used against you, both pre-Miranda, before you're arrested and being interrogated, and certainly afterwards. And there's no way to stop those statements pre-Miranda from coming in because it didn't apply. You didn't have an opportunity to invoke that right. So again, my advice is very simple. Answer what you need to answer, which is very basic. It's biographical information about your name and address and maybe date of birth and what have you, your insurance when you're in the car. But otherwise, decline to answer in a polite way. Ask if you're being detained or not. And if you are detained or you are under arrest, you'd like to have your attorney there or have one provided to you if you can't afford one. And then 2, invoke your right to remain silent, because again, there is no benefit. There's no talking your way out of something and doing so on the front end of the case. I'll leave you with this. In a typical criminal case, the state will provide discovery. Discovery is just another word for evidence. That evidence will go usually from the police to the state's attorney and then over to the defense attorney that you've either hired or has been provided to you. We then get to review everything that the state has by way of evidence. Police reports and videos and witness statements and if there's ballistics reports and medical examiners reports and number of things. We get all of that. Then we can try to make it make sense. How does this apply against my client? Some of this is relevant, some of it is not. And we can work through that if we haven't already committed ourselves to a story, if we haven't made admissions about being at the scene and having knowledge of different things. It makes the defense attorney's job that much easier and opens up the doors to a lot more defenses if you do not answer questions and provide information against yourself when you simply don't have to. Take a deep breath. Understand there are very basic bits of information you have to provide, and that otherwise you're merely applying your constitutional right to not speak, and nobody can hold that against you in a negative way. But the things that you do say certainly can and will be used against you later on in the process. I look forward to meeting with you in the future, answering other questions. Certainly we'll get into the comments and answer questions there. If you have a question or an idea for another video, by all means, reach out to the firm or comment again below to this video. Here to provide context, information, analysis that I don't believe is being provided anywhere else. And I just want to have the citizenship of Chicago, the Chicagoland area, Cook County, and Illinois broadly understand sometimes what could be very complex and difficult concepts. Have a great day. Bye.